Good morning, friends. Sat Sri Akal, Namaskar, Adab. This is once again the same case, Manalal Agarwal. Now his inheritors, because Manalal Agarwal had died, I think, in 2007. So the case which was remanded back by the Supreme Court orders by moving an application under Order 41-4127 rule, the case finally reached the court. A regular appeal was filed 378 of 2005, in which Manalal, through his legal heirs, Surya Kalabai Manalal Agarwal, Nand Kishore Lakshmi Narayan, Jivan Lata Mulli Devi, Ashu Nand Kishore, Ash Nand Kishore, and Messrs. Akash Investments, directors holding 9, there were some people made up. So, because Manalal had died in 2007 and the case LRs had to be instituted, so this came up for hearing. Now, during the pendency, the whole facts which I have already read in the earlier part do not need to be taken up again. How Manalal was in possession, how the sale deed happened in 1946, and how did that mortgage deed was redempted. So the original suit which was filed by Manalal, why was it withdrawn? The exhibits of written statements filed by either of the parties, especially the respondents number 1, that is the Union of India, filing written statements and amended written statements. These are very important, Exhibit 66 and Exhibit 105. So their entire pleading goes on 2 points now, that in 1903, these 4 villages were acquired from the ruler of Bikaner, who was the original owner. That is Karanpura, Padampura and Keshhar Singhpura and Kokanwadi. An amount was 37, which was originally stated as 25,000 something. So there is some variation, discrepancies, we will not get into those details. It has already been upheld that yes, suit property was an ancestral property of Kalabai, who actually sold it, and she bought it from Ratan Singh. So here, coming down straight, what were the issues? Whether the deceased Hiralal and Manalal were in settled possession of the suit property. It says yes. Whether the deceased Hiralal and Manalal were dispossessed by the respondents from over the suit property without due process of law in 1951. It says yes. Whether the suit is within limitation, it says yes. Whether the deceased Manalal and after his demise, his legal representatives were and are entitled to recover the possession of the suit property, it says yes. Whether the legal representatives of the deceased Manalal are entitled to get past means profit, if yes, and what rate. It says yes, rupees 500 per annum, but it sticks to that 1963 order only. Whether the imputed judgment and the degree are sustainable, no. Now, what is happening in this case? Now, we again rebrush ourselves quickly. The pleadings made were again of 7 acres, 24 guntas, survey number 20, originally called Suranj Kund Wala. A means profit of 1500 was demanded, and so on. Here the reference is even given to a Specific Relief Act section 34, which clearly reads any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or entrusted to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff needs not in such suit ask for any other relief. This section, the Specific Relief Act, is very important. In most of the cases, we file injunction suits for possession. But here it says Manalal was not in possession of the suit property on the date of the filing of the suit. It is well settled where the title of the plaintiff is under a cloud or disputed, and he is not in possession. necessary he will have to file a suit for declaration of his title to the suit property and then seek possession thereon. If the plaintiff does not file a suit for declaration of his title, then it would not be maintainable. So a beautiful finding comes into this case, that even if you are not in possession, how you can rake up your possession. So the main in this case which came back in 2005, Madhavrao DW3, who had tendered a lot of exhibits, disposes on behalf of the same statements, 1903 acquisition and all. The simple finding, there could be no doubt that the suit property title is within the limitation. Why? Because 1951 he is thrown, 1955 and 63 finally he files the suit. 55 he files one to be commended, and then finally 63. So it is under the limitation, and the new judgment which came in the passage after this judgment, that was of Surinder Kumar Vakil 1999, was discussed that GLR is an authenticated document and it does not need to be proved. So the plaintiff appealing on to PT Anklesha's judgment of SC Vishishta, where the whole process of considering the evidence in a particular case cannot be put to a pedestal on the proposition of law in another case. On the fact of each case, it will have to be found out whether the land in cantonment area belongs to government or whether there is evidence before the court in regard to actual tenure of that land. Till such evidence is adduced and found reliable, it would be unsafe to assume that the land belonging to a private person was taken over by the government in pursuance of one or the other of the regulations framed by the government. It is further held that there is no presumption of law that the entries made in the registers of the government property maintained by the cantonment authority are true until they can be proved contrary. Keeping in mind this legal position, I proceed to decide the nature of the suit property and nature of possession of the deceased Manalal thereon. So the court is giving two separate findings. One, it says, well, whether in possession or not, every fact for a property changes, of the suit changes. And second most important, it says, on just presumption that there were some rules or some regulations passed by the then British government or the department of today, does not amount that the presumption is to be taken that the land belongs to government or the cantonment authority. Surinder Kumar Vakil, it says, fine, the GLR is there, but you have to prove a contrary to it. It's very easy. I bet on the GLR is defunct. So this is how we keep going, and various discuss. Now Exhibit 259, which was put on in 1904, as per clause F of the resolution 259, it was decided that the intentions of the government should be asked. It was appearing that the ground of Bikaner Jagir was not required for barracks. There was a necessity to turn out the villagers. As per clause G, it was resolved that the villagers of the Bikaner land be allowed to cultivate their lands, paying the sum rate as formerly paid to the Bikaner Darbar. You take their land, you actually don't require it. This is the sections of that 1903 order exhibit speaks. Dig it out, get it from Aurangabad. It has to come in evidence of Babu Rao DW1 that after acquiring the land at measuring 918 acres, 39 guntas, the villagers were allowed to cultivate their lands. So preparation of GLRs, Bikaner ruler, this keeps going on, and then these land cultivators were even paying land revenue, which in Exhibit 245 have been clearly stated in 1931. The evidence clearly showed that after, let's say, the acquisition of these 4 villages from the Bikaner ruler, possession of the entire land was not obtained by the cantonment board. When the record shows that the land survey number 20 Karanpura called Suraj Kundwala was in possession of the deceased Ratan Singh, his widow Kalabai, it was incumbent on the part of the respondent to establish as to when possession of the said land was taken from the deceased Ratan Singh. Nowhere this evidence is coming. So, well, it's good that these such discrepancies were taken out. There is absolutely nothing on record to show that the respondents obtained possession of the suit property from either the deceased Ratan Singh or Kalabai or Hiralal or the deceased Manalal in due process of law. In no time it was shown. It is thus clear that deceased Manalal was in continuous process of this property and his predecessors. So these points were being discussed in the court here in 2005, which finally pronounced an order in 2013. It even discussed the limitation on Article 64 of the Limitation Act. 1951, he was dispossessed. 12 years, he had the right to file one, which he practically did one. So the limitation also stands with him. So what is going against him? So the court finally says the appeal is liable to be allowed with cost. The impugned judgment and degree are liable to be set aside. The degree for possession is liable to be passed in favor of the appellant. They are entitled to get future means profit. Consequently, a direction will be given to the department to make an inquiry on means profit under CPC Order 20 Rule 20. And the respondents, if desired, would be at liberty to take legal action to recover possession of the suit property on establishing their title thereafter as permissible under the law. So appeal is allowed. So what is happening? 1963 the man wins. And the case comes up till 2013. This case is only sustaining itself because Manalal Agarwal had brought in excellent evidence of the land records. There are some grey areas which he is missing on to, but since this land was not the bungalow area, which was not under the House Accommodation Act, this was not the civil area, it was basically the village area. If you even today see your cantonment, there are some areas in the cantonments which we may frame ourselves into a mindset were being used by the dairy farms or for the cattle grazing, and there was leases of agriculture leases given in this framework within the cantonment boundary pillars. So what actually transpired during that period in 2001 in Supreme Court, that the case was remanded back, was they were only gaining time. Manalal Agarwal would die. This frivolous notice of 1950 that all lands within the cantonment under section 3, 4, 5 of the Cantonment Act belong to government. If you read CLA rules in 1925, it clearly says why classification of land was being done. If you read 1899 Cantonment Code, it clearly says why are old grants being converted into leases. Friends, again and again I am saying the Britishers may have usurped all the land records. They may have done everything wrong for us in this country. But I am yet saying one thing. Had the Britishers not been there, we would have been a divided lot. Hindu kingdoms were divided into more than 800, 900 estates. This Akhand Bharat was not Akhand Bharat. These were petty chiefs. Every 60 kilometers or every 100 kilometers you had a king. The land record system was bad. The Akbari system was not being endorsed. The Raja of Bikaner was allotted a land for his uprooting because of a settlement during the Rajasthan regimes, and he was moved to Aurangabad. Now these were those grants which the Raja had actually given us to the villagers. These were those old grants which were actually revenue free grants. But when the Britishers came into the terrain, they started converting these old grants, which has been produced in this case of the Bikaner of ruler of Bikaner's grant in Aurangabad. These were those grants which were being converted, regularized into new grants. So these two findings are very clear in this case. Any land which was not classified was put under B4 or B2 was those lands which were surplus. Because these lands were never acquired, people were allowed to cultivate, Britishers were more keen on making revenue on these lands. I would respect if somebody could locate the present owners. This is Surya Kalabai. She was 80 in 2005, so maybe, God forbid. But we can always find the younger generation which is there. Akash Investments and Holding through its director Nand Kishore L. Kagliwal, resident of Akash Farms, Pathan Road, Aurangabad. Why can't we find these people? I was in Pune and I remember I told Pesi Inklesha, his case was won in the High Court, Bombay, that when you come to Supreme Court, you will lose. Because I know where is the grey area. So the grey area in that case was won, and finally on that very point it was taken out. In this case also, when it goes to the High Court, which is the Constitutional Court, again the redemption will work on these very factors. Old grants could not be given under TP Act, was not applicable on grants. So many things like this will crop up. We just have to suffix what is the definition of an old grant and what is the definition of a new grant. And this case is proven. Nobody on earth can take away this 7 acres and 25 guntas of land from this family. Because I've been always in the last 4-5 years been continuously saying we were old grants, never converted into new grants. Thank you. Good day.